Assalamualaikum warahmatullahi wabarakatuh. Today, my group's member and I will be presenting about consent of children to medical treatment. So, this is the list of my excellent group members.
Assalamualaikum warahmatullahi wabarakatuh. My name is Ahmad Ikmal HAKIM bin MUHAMAD RIZAL. My matric card number is 053017. Today, I want to share with you all about introduction this topic. Most countries in this world have different systems pertaining to adult and child patient. This is evident from the law applicable in each country. In Malaysia, Section 2 of the Child Act 2001 defines child as a person who is under the age of 18 years, and B, in relation to a criminal proceeding, means a person who has attained the age of criminal responsibility as prescribed in Section 82 of Penal Code. The term child is also synonym with the term minor. Black's Law Dictionary defines minor as someone who has not reached full legal age. Full legal age, as have been mentioned before, depends on the law of each particular country. There are countries such as Malaysia which provide that 18 is the full legal age. In general terms, consent can be defined as the voluntary concurrence by a person to the proposal of another. Consent is an act of reason and deliberation. A person who possesses and exercises sufficient mental capacity to make an intelligent decision demonstrate consent by performing an act recommended by another. Consent refers to the provision of approval or assent, particularly and especially after thoughtful consideration. To make it simple, consent is an act of voluntarily with a deep thought and consideration. In discussing the issue of the age of consent to medical treatment in Malaysia, reference will be made to several existing statutes, namely the Age of Majority Act 1971, the Child Act 2001, the Law Reform Marriage and Divorce Act 1976, the Penal Code, and the Child Witness Act 2007. The term child patient refers to a patient who has not yet to attain full legal age. For example, in Malaysia, that is 18 years to attain full legal age. The essential issue pertaining to consent to treatment by minor is whether they have the right to exercise their autonomy. Based on Article 12 Clause 1, United Nations Convention on the Right of the Child, UNCRC, provide that a child who is capable of forming his or her own views must be given the right to express those views freely in all matters affecting the child, the views of the child being given in accordance with the age and maturity of the child.
Assalamualaikum warahmatullahi wabarakatuh. Thank you for the previous presenter. I am FATHIAH binti MUHAMAD NIZAM, and today I will explain to all of you with regards to parental consent of children medical treatment. So we go to the first question arise here, where what is consent? Consent is the principle where an individual gives their permission relating to something serious, for example, a medical treatment. The consent must be obtained through the parents or lawful guardians if the patient is a minor. According to the most countries, consent is required whether it must be obtained from the parents or lawful guardian, and certain countries allow the children itself to give their consent. Next, we go to the countries that allow children to give their own consent. So, the first country is British Columbia. In British Columbia, where it is one of the Canadian territories, it was stated that the majority age is 19 years. There was no stipulated age with regards to the consent of minors in medical treatment. The Infant Act applied to an individual which was under 19 years of age. Part 2 of the Infant Act lists out the requirement for a child in medical treatment. Section 17, Clause 2 of the same Act stated that an infant may consent to health care whether or not that health care would, in the absence of consent, constitute a trespass to the infant's person, and if an infant provides the consent is effective, and it is not necessary to obtain consent to the health care from the infant's parent or guardian. In addition, before the consent was obtained, even it was given by a minor, the minor must know the consequences if he or she agreed with the medical treatment. The principle of consent is so necessary for medical ethics, and every patient has a right to give their consent. Next, we go to the second country, which are United Kingdom. The laws of the United Kingdom is almost the same as Canada, where minors aged 16 or over are entitled to consent to their treatment. This can only be overruled in exceptional circumstances. Likewise, adults, young people range of age between 16 or 17 are presumed to have sufficient understanding to decide on their medical treatment unless there is significant evidence. Children under the age of 16 can consent to their treatment if they fulfill the requirements, which are sufficient intelligence, the minor is competent, and understand natural impact on their treatment. This principle was known as Gilead competent. Gilead competent can be understood if we read the case of Gilead versus West Norfolk and Wisbech, where a mom of female child aged under 16 protests to Department of Health that allow the doctors to give advice and treatment to the child without the consent of the mom. Hence, it was held that a minor under 16 had legal competence to consent to their medical treatment or examination if the minor has sufficient intelligence and maturity to understand the consequence of the treatment and its impact. If the person with parental responsibility refuses to give their consent, then the court will release order if the medical treatment is the only best interest on behalf of the minor. Whereas in the situation of emergency, if waiting for parental consent would place the minor in risk, then the treatment can proceed without the consent. So, we can understand that Canadian law is a bit rigid in determining the age of consent for the child. It can be seen from the Infant Act itself, where it applied to the young person under 19 years old. But, as a comparison for UK law, the minor who was under 16 years of age can obtain their consent to a medical treatment provided that they know the consequence and impact of the treatment. Besides, the minor also must have sufficient maturity and intelligence before the medical treatment could be put into practice. That's all from me. Thank you so much for your attention.
Assalamualaikum warahmatullahi wabarakatuh. My name is MURSYIDAH binti LUQMAN HAKIM and my metric number is 053073. So I will be sharing 2 countries that does not give right to the children to give consent to their own medical treatment. So the first country is Japan. Based on Article 4 of the Child Welfare Law of Japan, child is defined as anyone below 18 years of age. However, in Japan, patients younger than 15 years old are not competent to give consent to medical treatment. So, in certain cases, if both of the parents refuse to give consent and it is impossible to provide treatment, the healthcare providers of Japan will report the case to the Child Protection Agency. If only one of the parents refuses to give consent, and the healthcare providers of Japan will operate on the patient with the consent of the other parent in case of an emergency. Moving to the second country, which is India. According to Section 3 of Indian Majority Act 1875, the age of majority in India is 18 years old. Therefore, a person who has not completed 18 years old is a minor. So in India, before performing any procedure on a child below 18 years old, it is advisable to take consent of a person with parental responsibility so that its validity is not questioned. Moreover, in India, they define competent as every person is competent to contract who is of the age of majority according to the law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject under Section 11 Clause 3 of the provision.
Thank you, dear previous presenter. Now, I'll be presenting about the benefits of allowing underage to give consent toward medical needs. Briefly speaking, there will be 5 subchapters that I will explain. Firstly, by validating underage consent, every emergency case and trauma can be resumed with ease. Instead of debating whom the power of authority shall fall, either the guardian or medical practitioner, the matter that we should consent is the child's condition. It may take time to wait for their legal guardian. Other than that, not all of them presented by responsible custody. Hence, they shall be given their voice to state their opinion. Secondly, allowing them to give consent will give benefits to them since they may act on what they think they deserve and what is best for their bodies. It is not only giving them powers to permit the operation, it also gives them the ability to refuse the procedure. Thirdly, this will help to cope with their mental health. Did you know that mental diseases are rising in the communities? Depression, which is mainly stated as a silent cancer in the society and often shows initial symptoms among teenagers. Therefore, they may seek someone professional without worrying about the problems they are facing that might affect those they love. Fourthly, their maturity that usually is questioned. Acknowledging children's consent may boost their confidence in conversing with themselves regarding their needs. According to medical studies, the sophistication of thinking will start to develop at the age of 13. Even so, there are still proof that not all adults mature enough. Therefore, what makes them different from children? Along the line, if children were able to see the nature of the matters they are discussing, they shall be considered mature. It is a way that could help them to slowly expose to adulthood. Lastly, reading the statistics, children were born without legal parents are worsening day by day. The question is, who will take responsibility for them if they cannot take care of themselves? We cannot deny that tons of NGOs would help them. However, it is only in traceable cases. The nationwide statistic shows that 4,992 illegitimate children were born to young mothers aged 18 and below in 2017. How about those who were born without proper registration and were unknown to the world? Hence, it shows that acknowledging underage consent will help us preserve the communities as a whole.
Thank you to the previous presenter. Now I'm going to proceed our presentation on why children should not have rights to give consent on their own medical treatment. Before that, let me introduce myself. My name is BINTI SHARIFFUDDIN. First of all, it is because of competency of pediatric patients. As we know, consent is not valid if the patient does not understand its meaning or if patient has been misled. Medical decision-making in adolescents will be tough and more complicated as they will be easily affected by different psychosocial factors such as peer pressure, impulsivity, and risk-seeking behaviors. Hence, their maturity level can be said is still limited and it will be quite difficult for them to understand any circumstances of the decision they made very well. Second one, it is because of complexity in decision making. In determining whether treatment would work, how likely it is that it would work, and how to weigh up the risks and benefits of treatment are such big challenges. There will be many issues arise and maybe various views, especially in deciding whether to continue life support or discontinue the life support, or whether to provide experimental treatment or not. Hence, the decision made by applying parental autonomy will be more relevant to the child's best interests.
In conclusion, it is clear that there is a legal uncertainty regarding the age of consent to medical treatment. Therefore, it is suggested that there are specific statutes to give rights to patients who are still minors or someone who did not attain the age of 18 yet to give their own consent to medical treatment. Next, a specific age bracket must be determined in which a child patient is allowed to give their own consent to the treatment. Children of that specified age bracket must be presumed competent. However, this right must come with a proviso. For example, consent can only be given by child patient if it does not involve a life or death situation or an irreversible procedure such as organ transplantation. In such situation, parental consent should and will be resorted to. Recommendations for future research is needed in this case. In studying a standardized assessment instrument covering all 4 relevant dimensions of competence, including a study of population children covering the full age from range 7 to 18 years old, in order to improve information provision and assessing relevant contextual data.